short. Sherry Broder is a litigator in Hawaii. She specializes in complex civil litigation and social justice issues. She most recently, and I'm sure a lot of you saw this and were hooked in by it, won a $2 billion settlement on behalf of torture victims from the Philippines during the Marcos regime, which is one of the largest personal injury settlements in U.S. history. And she's also well known in Hawaii. She was the first woman president of the Hawaii Bar Association and has been honored both as a litigator and as someone active, particularly in the social justice and human rights community.
Okay, so the next major event really in the history of Hawaii for Hawaiian people was statehood, when Hawaii became a state. There was never a separate plebiscite for Hawaiian people at that time, whether or not they wanted to become part of the United States and be a state. But and that's something that people still complain about today. But in any event, Hawaii became a state in 1959. At that time, 1.4 million acres of the government lands that had been held by the federal government were transferred to the state of Hawaii. And in the Admission Act, it says specifically that one of there are 5 things that these lands are to be used for, and one of them is for the betterment of the conditions of the Native Hawaiian people. And so, as Professor Van Dyke was saying, the federal government has recognized all along an underlying responsibility and trust to the Native Hawaiian people that runs with these lands. 350,000 acres, though, were kept by the federal government, and they are all used either for national parks, but for the most part for the military, the U.S. military. So for the first time in 1978, after the Constitutional Convention, there was added to the Hawaii State Constitution a provision to establish the Office of Hawaiian Affairs. And so I was actually the Deputy Chief Attorney at this Constitutional Convention, and I was assigned specifically to the Hawaiian Affairs Committee. And people always say, well, you were asked, is it constitutional to establish the Office of Hawaiian Affairs? And my answer always was, let's do it. And so they did. They established the Office of Hawaiian Affairs, and it had the assets of Hawaiian people in it, and it was a Native Hawaiian only vote for Native Hawaiian only trustees. That case went all the way to the U.S. Supreme Court on whether or not you could have a trust with an election paid for by the state government for Native Hawaiians only to vote in. And the U.S. Supreme Court in Rice versus Kaitana said we couldn't do it anymore. But nonetheless, what ends up happening is Native Hawaiian only people are elected to be the trustees of the trust, because I think the community generally recognizes that Native Hawaiian people should be managing their own resources. So this was a big deal, and the Office of Hawaiian Affairs became created, and it's become an advocate for Hawaiian people and has filed different lawsuits to recover the assets and resources of the Hawaiian people. Hawaiian language became one of the 2 state languages, which was a very big deal because it used to be against the law to speak Hawaiian in Hawaii. And it was also added protection of traditional or customary rights. It became a constitutional protection for Hawaiian people. So in 1993, Congress passed the apology resolution acknowledging that the overthrow was illegal. So we lawyers thought, well, gee, Congress has made an admission against interest on behalf of the United States of America. I mean, that must give rise to a claim. And so we thought, well, we should sue. And so we filed a lawsuit based on this admission, and also other important provisions in the apology resolution where the United States of America admitted that the lands were taken from the Hawaiian people without compensation and without their consent. So we thought this gave rise to a really good claim. They lost their inherent sovereignty, and they never directly relinquished it. And then Congress also recognized, sort of in accord with what's required by the BIA to reconstitute and become recognized as a be federally recognized as a tribe. You have to have your continuing cultural identity and continuing relationship to your ancestral territory. So then Congress called upon the President and the State of Hawaii to engage in reconciliation with Native Hawaiians. And there was no specifics given in the apology resolution as to what that means. What does reconciliation mean? But we would always argue in court that reconciliation means something. It doesn't mean nothing. It means something. And it means that there must be efforts made to resolve some of these outstanding claims. So we would say it requires something to make amends to be positive. Okay, so we sued on behalf of the Office of Hawaiian Affairs. It was our client. And what we did, though, was even though we thought that the apology resolution gave rise to a claim, we thought that might be too big a mountain to climb. And so we tried to narrow the case down. And we asked for a moratorium on the sale of the public lands. There had been preceding cases. This is another case by the Hawaii Supreme Court. And other cases that had been brought over land claims or over money, revenue claims, had been dismissed on political, non-justiciable grounds. So that's why we narrowed this case down to a moratorium. So we didn't say we're entitled to anything in particular, but that we should have a moratorium until this reconciliation effort and process was accomplished. So the case arose out of activities that the HCDCH, the Hawaii Housing Community Development Corporation, was going to do. And actually they were going to take some of these lands, these former government lands of the monarchy, the Hawaiian monarchy, that had been in sugar production since the 1850s on Maui, in Lahaina. So these lands had been rented all these years to the sugar planters. And you know, in the last 30 years in Hawaii, our economy has changed. We don't have sugar plantations anymore. We don't have pineapple plantations. Those things are done elsewhere. So it was the first time in 150 years these lands were free again. And so the state was going to take them and turn them into middle-income housing, into golf courses and shopping centers. So it was kind of a perfect plan to sue over, because it wasn't anything that was going to in any way benefit Hawaiian people, and it was going to be taking lands that had not been utilized for anything but sugar for many years and turn them into real estate development. So we asked for a moratorium on the sale or transfer of any of the ceded lands. We looked, there was a case in New Zealand very similar to this that the Maori brought, and we used that case as an example for what we thought the court should do. And as a result of the case in New Zealand, the Maori did have many different settlements that came about for them. In addition, there had been a case in Alaska where Secretary Udall of the Department of Interior had put a moratorium on the sale of any lands in Alaska because of the claims of the native peoples there. And he said until those claims were resolved, there was going to be a moratorium. Well, in the Alaska situation, there was petroleum, and the petroleum companies wanted a resolution on the land so that they could go get their leases and do drilling. So they went to Congress and put pressure on Congress to pass the Native American Claims Settlement Act so that the title could be clarified and they wouldn't be taking, you know, unnecessary risk and taking activities. In Hawaii, we don't have petroleum, and so we don't have any strong, powerful economic interests in Congress pushing this thing through. We also cited a case that went all the way to the U.S. Supreme Court in the early 1900s on behalf of the Pueblo Indians, where a moratorium was put on the lands. So in New Zealand, as I was saying, the court found that there was an obligation to the Maori people and that there was a moratorium. And of course, these moratoriums, what they do is they do trigger a discussion and a settlement process and some activity by the governments to deal with the native people so that this inability to alienate the land can be freed up.